Hello, class, and welcome to the module on policymaking in the courts. So for this module, we read Grossmann and Swedlow, 2015. And in that article, they're considering what is the role, what is the influence that the judiciary plays in policymaking in the United States since 1945. They do a robust analysis and offer some really important insights. So let's take a look at some slides.
Okay, here we go. Policymaking in the courts. Now, in this article published in 2015, so relatively recently, Grossmann and Swedlow do a comprehensive study of the degree to which U.S. courts make public policy and influence public policy making in a significant way. Their approach is both robust as well as novel because they are not only considering the direct impacts of the federal courts on policymaking, wherein the courts make policy on their own, they're also providing a new interbranch perspective on judicial policymaking that attests to the ability of one branch of government to influence another policymaking branch in the kinds of social reform it pursues, enacts, and implements. But first things first, what literature are they building on, right? What have previous theories and findings suggested about judicial policymaking? Well, broadly, the courts have been perceived as weak with respect to their ability to make or influence public policy. The authors quote Dahl, a preeminent political and social scientist, in saying that by itself, the court is almost powerless to affect the course of national policy. Another prominent judicial scholar, Rosenberg, offers that the courts can almost never be effective producers of social reform. And then this is the dominant viewpoint even today, especially with respect to Dahl's words, by itself. This by itself is reflected of the prevailing notion that the court is dependent on Congress or the executive in any policymaking power, and can, in Howard and Steigelwald's terms, only have real impact if they keep their policymaking aligned with the executive legislative core.
Okay, so Grossmann and Swedlow are breaking from past research, not just with respect to their findings and the contribution that they make, which we'll talk about a little later, but also with respect to their methodologies and the way that they conceptualize the influence of the judiciary on policymaking. So let's take a look at that more specifically.
The authors are different than past researchers and are really taking an important approach here because in their measurement of policymaking and influence, not just in the federal courts, but also across all the branches, they can speak to questions and make inferences that other scholarship has not been able to. And in this way, they're making a big contribution. So now, like all the scholars we have studied, the authors take care in their conceptualization and their operationalization of policy influence, right? They have to be careful about this and very specific in their definitions, right? How should judicial policymaking and influence be measured? How should policymaking and influence be measured more broadly? Well, Grossmann and Swedlow take a kind of meta approach. And now these meta approaches traditionally describe when scholars study what's been studied, right? That's why it's meta. And now that isn't exactly what the authors are doing here, but they are looking towards past experts, right? They're reading books on policy histories, policy narratives, and taking what is originally a sample of over 800 of these books, these histories, and collecting data from them about which branches played what role in shaping policy outcomes over time. Now, as they're collecting data, their sample, it is broken down a little bit from 800 to in the 200s. And they are, whittling down their sample based on some important qualifications. For instance, these books need to be thinking about actual policy change rather than just describing the policy, which is a key distinction not just for the authors, but also for our understanding, right? Because we're thinking about policy processes. They're also taking into their sample studies that look at policy change that's happening over the course of at least 10 years. And that is also key, and we'll discuss why in a minute. And finally, they're putting branches on equal footing in long policy-making processes.
Okay, now there are two critical points worth underlining here. The first is with respect to time. and how the authors are looking at policy processes that have extended for at least 10 years. So what does this mean practically? Well, it means that we're thinking about, similarly to Burstein, how policy proposals can be there for long periods of time within a Congress. It's also thinking about what we thought about with the executive, right? How, small executive orders can in fact have longer and longer term consequences over time as they become more entrenched. That the implementation of different policies, whether they're enacted in Congress, in the executive, or actually through the courts, can take long periods of time, and every decision that's made with respect to their implementation can influence the policy outcome that we know in society. So in many respects, the authors are paying close attention to path dependency here, right? How do policies and policy change become entrenched? And thus, how are they, how can we consider them significant policy changes? And how do they do this, right? Well, they do this, and this is the second point for emphasis, they're looking not just at one particular stage of the policy process, right? And we know about this too. We know that the policy process, policy change can happen all throughout the policy process, and it can go back and forth and be changed and rechanged, that this process is in fact fluid. And they're paying close attention to that as well, thinking about the process on the whole, rather than in any one specific space or stage. How do they do this? Well, they do this through the study of narratives, right? They look qualitatively at the narratives produced by experts in the field, by policy historians who are writing books, entire books on particular policy issues and thinking about how they changed and why. And so with that in hand, they can look and collect data on the whole process of this. And this is what they do. It's quite a significant endeavor and something to really be noted and respected in terms of methodology.
Now, let's take another moment here to consider the sampling universe, right? What is their overall population of interest? Well, they're interested in significant policy change in the United States in the broadest sense, right? They're looking to these policy histories to gather data on policy that, in the historical sense, resulted in big changes in the national and social practices in our world. They're thinking long term. They're thinking important impacts, sustained and entrenched. And they want to know about where, across any and all of the branches combined, these impacts originated, right? So this is a key strength in their study because they're not just thinking about the courts. Their sampling universe is not just court activity, right? And they are also carefully collecting data on the issue areas within which these kinds of changes occurred, right? Providing an additional rich source of variation and insight.
Okay, so we're going to stop once again to make another point of emphasis. And this one is super important and very, very cool. So it has to do again with this sampling universe. And what distinguishes Grossmann and Swedlow's work from those authors and past scholars that have been thinking about the influence of the judiciary in policymaking. Because what the other scholars in the past researchers have been focused on, what universe they're looking at has been past court cases. But what Grossmann and Swedlow are looking at, what their universe is, what their population of interest is all public policy that's been significant policy changes over time. And this is a key distinction. Let's figure out why. Let's write it on the board. So past research, right? They're interested in, again, all court cases. And what ends up being there is that's their denominator. Okay. Now I don't know the exact number of court case. I don't know this number, but let's just for illustrative purposes estimate that it would be about 10,000. That could be completely off, but for illustrative purposes, let's just call that 10,000. And then they count all the significant judicial federal court decisions that made public policy impacts, where the court made policy. And then they say that is X. Now, what about Grossmann and Swedlow? Well, their universe is not all court cases. It's all significant policy change. Policy change. Now that denominator is in fact much smaller. It's less than 1,000 based on the sample that the authors collect. But we'll just call it 1,000 again for illustrative purposes. Now they're going through and seeing the same X, right? The same number of federal court cases that made policy. But what we're seeing here is that whereas this ratio might be dramatically underestimating the degree to which the judiciary is engaged in public policy making, this is arguably more accurate, right? And it's a much higher ratio because they're thinking about significant policy change, not everything that the court does. So just by simply changing this sort of universe from which they sample makes a big difference and a massive contribution to the overall work and the understanding of what is the role of the court in making public policy.
All right, let's take a look at their results. So overall, they find that federal courts made or influenced policymaking by Congress, the President, and administrative agencies in 23.3% of significant policy changes between 1945 and 2004. A statistic that should not be interpreted as quote-unquote weak, as past research would suggest. Okay, let's check out this first figure, figure 1. Figure 1 is showing the number of significant policy changes that took place in each branch, and the number of policy changes historians credit each branch with influence. So over here on the y-axis, we have the count, right? These are the number of significant policy changes. And then in black, we have the policy changes made directly by that branch. And then in gray, we have the policy changes made indirectly by that branch. And then there is the total. So what can we see here? Well, when we look at the judiciary, which is obviously the subject matter of this article, we see that the federal courts had direct influence on 125 of the significant policy changes made over this period of time, which is 15.8% of all these important policy changes. So that's a substantially high number. That's higher than one might have expected given the past research in this field about judicial policy influence. We also see that there's an additional 59 major policy changes in which the judiciary or federal courts had an influence on other branches as they made these big changes. What else we see here is that with the executive, right, this black bar here, the count here with respect to how the number of policy changes made directly by the executive branch is pretty similar, right, is analogous to that of the judiciary. We also see that the executive plays a substantial role in influencing other branches, mainly the legislature, and that the legislature has the far and away most direct influence on policy changes, which is to be expected. Okay, now figure 2 is interesting because it's giving us some context. It's providing some descriptive statistics showing the difference between total court decisions, salient court decisions as defined by the New York Times, and policymaking influential court decisions that the authors are measuring and collecting data on. Now we see here down here, this is the number of significant judicial policy changes from policy histories. Quite low, for instance, in comparison to the New York Times designated salient court decisions, and very low, proportion of the overall total Supreme Court decisions. We can tell from this that policy historians are not just handing out the designation of significant policy change at anywhere near the rate that scholars are, for instance, designating decisions as salient. And that's about the fact that we're not thinking about what's newsworthy here. We're not thinking about what's going to garner public attention. We're thinking instead about what is changing the social fabric of our policy world. What is changing history over time with respect to public policy. Okay, but now thinking more in depth about the courts and how they're influencing policy, this is going to change significantly depending on the time period and the issue area that we're considering. Now, figure 3 is depicting the percentages of policies made by federal courts during each presidential administration, along with the percentage of all policies that were made by other branches but were also influenced by the judiciary. So, over here on the y-axis, we have this percentage, and this is the percentage, again, of policy made in the judiciary, whether it was made in the judiciary or influenced other branches by action in the judiciary. And this is the percentage of all of the significant policy changes during that administration. So again, we have here on the x-axis the different presidential administrations. Now, what do we see here? Well, during an average 4-year period, the federal courts made almost 15% of significant policy changes and influenced another 7% of the policy changes made in the other branches. Again, this is not a small number. We do see some interesting variation here. So federal courts made about 20% of the policy changes during the second Truman administration, as well as during the Nixon and Ford administration. We see about 15% of the policy changes being made during the second Reagan administration, as well as with H.W. Bush's administration. And these are all, again, in the black, which represents the policy changes made directly by the judiciary. Now, judicial influence on other branches was highest during the second Clinton administration, see right here, followed closely by the Nixon-Ford administration, over here. Okay, but what about with respect to the issue area? What percentage of policy changes are being made either directly or indirectly in the judiciary? How do we see variation across this with respect to issues? Well, let's take a look. First of all, we see that over 40% of the policy changes in criminal justice, as well as the policy changes with respect to civil rights and liberties, are happening over this period of time directly within the courts. We also see that almost 30% of policy changes are being made directly in the issue of finance and commerce. And this is also true for social welfare policy. We see that almost 30%, see right here, 30% is being made directly within the judiciary, 30% of all policy changes in social welfare. And this is unexpected that this is occurring in social welfare as well as in finance and commerce. Now, in turn, another interesting thing here is that with respect to the indirect policy changes, we see that while a low percentage of direct policy changes are made in the courts with respect to the environment, environmental policy is indirectly influenced almost 20% of the time in the courts. And this is a pretty substantial number. So overall here, we find that federal courts made or influenced about half of the policy changes in civil rights and liberties and criminal justice, about a third on finance and commerce and social welfare, and about a quarter on education, the environment, and labor and immigration. This is a substantial policy influence over time in these issues. Less so, for instance, in issues like agriculture, housing and development, and health.
Okay, so let's take a moment here to just discuss some major takeaways. Now, first, right, the authors find that there is a consistently significant influence of the judiciary in public policy making since 1945, right? This is the post-World War II era. So that's one. It's consistent and it's significant. We can take that as a break from past research that has said that it is weak. Now, second, that it's not just the influence direct, but a lot of the influence comes indirectly, right? How the judiciary can influence the executive and how the judiciary can influence Congress in their shaping of public policy. That is also key, right? Because it's thinking once again about what we talked about with respect to Jenkins and Milkus in the post-World War II era of public policy, that this separation of powers is more of an illusion than a reality when it comes to significant policy change, and that the activities of one branch are influencing the activities of another and another, and that path dependency is important in all of this story. So there are a lot of different things to tie together here, and we're going to do that in class. In the meantime, stay well, and I cannot wait to see you on Tuesday.